Good morning, everybody. Welcome to the event, which is held by the Research Center of Private Law, named after Alexeyev, at the Office of the President of the Russian Federation. I'll moderate the session this morning. And first of all, I would like to agree with you on the format of our discussion. And to begin with, I must apologize for my voice. The problem with my voice is the result of being 5 meters away from Sergei Mazaev, listening twice to one of my favorite songs, the first Ray, the First Snow. And then at the end, there was another well-known song, Do Svidaniya, Mama. Goodbye, Mother. And, well, those of you who were at the event do know how it was and when the event finally came to an end. Now, well, I have with me this extra bottle of mineral water. And so, dear colleagues, I'm not going to introduce the speakers to you, but we would rather begin our discussion of the issues. I would like to address, though, all the speakers to make sure that we do not express our own ideas, but also listen to the concerns expressed by our counterparts and colleagues and answer questions of the audience. So we are planning to discuss different issues, and we will begin with the issue that I never thought in the past would focus our attention that seriously. And it's within the range of 2 or 3 issues that I really do not like in the field of law. That's the problem of major deals and deals with the interest that actually undermined the stability of circulation in the Russian Federation. We have a unique system of regulation that you can find nowhere else in the world, and our discussion and comparisons demonstrate that. And we will have 2 presentations dedicated to this topic, and attention to this issue is first of all addressed because we hope very much that the situation is going to change for the better, because the situation at present is rather complex and unclear. And so one presentation is by Alena Kucher, the other one is by Alexander Kuznetsov, and we had to decide who was the first to speak, and that was not easy to do it, indeed. And I remembered that's the story when they say there is a tradition to let women enter the caves first, since primitive days, the days of primitive culture, when it was not that safe to enter the cave. It was not that safe in general for people to live on the earth. And anyway, so I don't think we should discuss that, but anyway, we'll give the floor to Alena Kucher, and I would like to ask all the speakers not to go beyond the brief presentation and then comments and questions. So we definitely will take time from the other speakers, and well, you can actually be quite open about that and mention those whose time you are abusing. Now, good morning, dear colleagues. The topic is quite important, and we're at a dead end in a way. This problem destabilizes our circulation. Now, the major deals issue actually is the story that began 2 years ago, when in the roadmap for the creation of the International Financial Center, there was a clear request to settle the situation in order to carry out this work. And probably some of you took part in it, in the discussions that were held in the Ministry for Economic Development. And those who worked on this draft law by 2014 believed that the text was well coordinated, but as we discussed at other roundtable discussions, the process was not properly synchronized with the civil code amendments, and there was a conflict of interest indeed. The civil code looked into this matter, into the matter of the conflict of interests, and so when the draft was practically final and when it was planned to submit it to the government, then still it became possible to look at this draft law with in view of the amendments of the civil code in the chapter for legal entities. And so the results of that particular survey proved quite negative, because there were some attempts to settle certain matters, but mostly those were technical issues. And how should we get the quorum of those who never meet? How should we assess the deals, particularly if we take different ways of payment, and the judicial practice, and all this had to be taken. So the draft law was actually based on these details and on the practicalities, while in the civil code the process followed its own route, and there were interesting articles introduced which also helped to work with the conflict of interest. First of all, we talk about Article 174, which makes it possible to recognize void the deals which work against the interests, against public interests. And secondly, it's the strengthening of the Institute of Responsibility of the Directors and introduction of the Institute of the Responsibility of the Responsible Individual, going beyond the Article 105, the relationship of the main office and the subsidiary. And when we looked at the civil code, we realized that we need to step back a bit in order to understand better what kind of problem we're tackling with. And well, of course, the technical issues should be put aside, we decided. We need, first of all, understand what the purpose of the major deals is, and with the interest involved. First of all, of course, it's the matter of the conflict of interests we're dealing. And the problem of the conflict of interests is extremely interesting in the corporate law. It's imminent. And as you understand very well, when there are several subjects who want to achieve a certain common goal, they either sign an agreement in the and there's a partnership and they achieve the goal, but then they are subjects vis-a-vis the circulation, and they are trying to get their goal together in a solidarized way. But there is a second way. There is a common interest as well, and it is possible to have a sort of an intermediary as a legal entity. And when this subject appears, this entity appears, then there emerges a very interesting problem of the tension, because there is an independent entity that is responsible for the circulation. Does this entity have its own interest, or it just reflects the interests of the parties? And is it possible to hide behind this particular curtain, so to speak? Or maybe this entity should have its own interest, and it should bend to the participants who give birth to this entity to carry out its own policy and demonstrate its own interest. This is a very interesting issue indeed, which is made even more complex because the parties begin to hire, in order to manage this entity, professional directors who have their own interest, although they, in this case, we can understand the interest of the parties, but the directors should not have their interest. They should act in the public interest, and we will discuss this matter. They really should act in the public interest, but nonetheless, the tension of the conflict of interest emerges. And so this problem of the conflict of interest can be resolved through several approaches. First of all, there are three groups of these ways. First of all, it's the preliminary control, when we presume that under certain circumstances the tension is going to be most obvious. So we're trying to control the situations, and through the board of directors or the shareholders, if we talk about major deals. And so the shareholders can decide whether there is a conflict of interest and on whether we're going to have this deal or not. So this is the forward control, so to speak. But this is quite formal because we are creating a presumption. There is probably a conflict of interest. That's approve or disprove the deal. The second approach, later control. The deal is in place, and if it is revealed that it was concluded with the infringement of the public interest, and when it is known that there is a certain individual that demonstrates its own interests and acts in favor of his own interests, then of course we can decide what to do with this deal. And the third, we are not going to terminate and to liquidate the deal, but we should just hold responsible those individuals who created the conflict of interest and acted in their interest. At the beginning of the 1990s, we mostly dealt with the first approach, and we have been using it for almost 20 years. We created presumptions when we believed that there could be a conflict of interest, and then we push the deals forward to approval. The third approach, overcoming the conflict of interest with the prosecution for that, has never worked. And if it actually worked, then there was a possibility to contest the deals, but actually this happened quite rarely, only in case there was an obvious infliction of the public interest. Then the post factum control, that's Article 174, and there are clear clarifications already saying that the post factum control works irrespective of the forward control, and there must be certain criteria observed, and the deal can be recognized void under the circumstances. What's new? The legal positions associated with the plenary decision on the responsibility of directors is part of the legislation now. So there is. So we're also using the third mechanism, but we're still within the framework mostly of the first mechanism, and we've been doing that for over 20 years. So here is the situation that we're facing. It's quite sad. It has already been mentioned whether we used to have just the forward control, and it's inconvenient for the circulation because it's really the deals should be approved. And it's quite expensive for the circulation because there is quite a heavy load, and in order to approve the deal and to avoid the conflict of interest, a lot of effort has to be put in. And if we create conditions for recognizing it void, then it is the main destabilizing factor which led to quite a lot of deals with interest manifested. So this destabilizing control was strengthened by the post factum control and by the responsibility of the directors. And so we lost the balance. And so taking all of that to the Ministry of Economic Development, we managed to stop the technical work, and a new concept was developed, and the
developers proceeded in the same way as they work on the civil code, but on a smaller scale. They have restored the concept, they described the task and the means of solving the tasks abroad, and the means of solving the tasks were in Russia were proposed, and draft law was developed on the basis of the concept, and my colleague will detailize on it. In the course of working on the concept, we have seen that forward control exists in certain jurisdictions, but not in all of them. And mainly all the jurisdictions use these three types of control: forward, subsequent, and responsibility of the directors. And the German model mainly emphasizes the responsibility, and post factum control, such as a possibility of destroying the transactions, operates in a different way. And the directors have the right to destroy the transaction, and the shareholders make them responsible. The shareholders have no possibility of post-factum control. Forward control is suited to certain small transactions when a loan is granted to the director of the company and the balance is shifted to the other side, and it creates a smaller load, and thus it is really related to the conflict of interest. So what happened with us, because we only have forward control and we tried to work at maximum with it, realizing that de facto that forward control doesn't cover a great number of the conflict of interest. The presumption when the transaction had to be subject to forward control, we increased it as to the affiliated entities, whether we have to take into account under forward control that possibility in each particular case to pursue our interests. Those such cases are infinite, and in forward control you won't be able to capture it. And that was the only thing possible, and we tried to increase the number of cases when we need to add forward control. And the situation was not suitable for everyone. It was not suitable for minority shareholders, for corporations who realized that this load would be senseless and would interfere with the turnover and would create unnecessary work to be done. Half of the legal department are catching the interest transactions, and there are some additional departments engaged in that work, and that would be a senseless load, and the board of directors receives those packages of transactions when the department has captured the possible criteria of the transaction with interest, and it was submitted to the board of directors, and the board of directors is not happy due to the enhanced responsibility regime, because they cannot just browse through all these documents and understand where the conflict of interest is available, and these approvals were rather formal, in fact, and the risk remained there. So everyone was discontent, minority shareholders, corporations, and directors. So the problem has come to the fore, and not only stabilization of the turnover, but the less loss of the essence of the institute of major transactions. We needed cardinal reworking, and it happened in the draft law. As to major transactions, forward control, I will give an example. Forward control is not used, for instance, in Spain, Greece, Mexico, the Netherlands, Switzerland, Sweden, Slovenia. In Germany it is truncated, but forward control is available in the UK only for transactions for the companies of premium listing: France, Australia, Portugal, Belgium, Israel, Italy, the USA. We have a very good study of international experience carried out by OSD when there were debates on affiliated entities and conflict of interest. Last year, the study was presented, and foreign experience is quite pronounced there. How you can capture the conflict of interest in what countries, at what level, when the transactions are approved. As to the major transactions, I will add a couple of words, and then I give the floor to my colleagues. As to the major transactions, the situation is unique. That institute we do not perceive in this way as for what it is intended. Due to the fact that we had an unacceptable situation of combating the conflict of interest, we started to use a major transaction for the same purpose, and we think that that is control of removal of the assets from the society in large amounts. In fact, that is controlled by the transactions of interest under these three types of control. A major transaction is a different thing. Here we mean certain events and activities of the society which change it fate drastically, so that is not a non-corporate reorganization, and so the solution of a decision of that cardinal change of the fate of the society. When you sell out that property and you lease out your property and you become you get a rent, and that is a different mechanism of doing business and different structure of the business. And to effect such a transaction, when you transfer, lease out your property, is we need to take into account the interests of the society at the highest level, as for instance by the General Assembly, the General Meeting. The same with large transactions. We have to, that has to be decided by the Board of Directors and by the shareholders. We shouldn't bring down those thresholds, and now the threshold of the major transaction is 25%, and there were proposals to reduce that threshold because 25% is a lot of assets, and here we proposed to go backwards and to analyze the purpose of the institution and to rewrite the criteria of major transactions so that that institute would perform its functions. I have intrigued you, probably you. That's how we came to what is being offered now, and I'm giving the floor to Alexander, who will discuss the concepts involved in the draft law. Just a few words by introduction. I'm Alexander Anatolyevich Kuznetsov. I have been long studying the issues of corporate law, and currently he is a member of the Ministry of Justice of the Russian Federation. Before that, we worked jointly at the High Arbitration Tribunal. He was a part of the analytical unit, division of the private law. He was mainly responsible for the matters related with these problems related with corporate law. He is also the author of the article on major transactions, major transactions with interest, and that is a collection of papers published to the anniversary of Tchaikovsky, and you can get acquainted with it. Please, Alexander Anatolyevich. Good morning, dear colleagues. It is rather difficult to take the floor after Elena Nikolaevna because she discussed the major conclusions of that draft law, but I'm not going to talk only about this draft law because it was prepared by a different ministry, the Ministry for Economic Development. Unfortunately, they are not attending this round table now. The Ministry of Justice participated actively in drawing up that draft law. And as I have mentioned, I would like to place major emphasis on the problems in this sphere. They have been partly mentioned by Elena Nikolaevna. I would like to add the first question which arises among the laws that are probably not absorbed into the corporate law due to that novelty that something will change in that sphere. Are the changes, and why do we need those changes? Probably recently extensive amendments to the civil code were made to the chapter on legal entities, and many things have changed there. It is rather simple to answer that question. Amendments to the civil code were extensive, and they solved the question of a global question for all types of legal entities or for a large body of legal entities. For corporations, new classifications were introduced. It was not aimed at solving the problems related with institutions of certain organizational and legal forms, such as, for instance, major transactions and transactions with interest. As to the causes, there are two types of causes. First, strategic and political legal reasons. It is, well, not so fearful that in a certain period of time we regularly analyze our legislation, we compare it with foreign specimens of law, and we understand that probably something has to be improved. In Europe, particularly after the beginning of the 2000s, when the European Court confirmed the right of the companies to be instituted in any jurisdiction and to operate in a different country, they realize what is competition of legal orders. I communicated with my colleague, and even the conservative legal orders, such as Germany, now have to reform their legislation, making it more convenient. In Russia, we also shouldn't forget about it, and we should periodically add some innovations and amendments. And second, legal reasons. After making amendments to the civil code, we have a very strange situation in the law on joint stock companies and open joint stock companies and closed joint stock companies. There are two institutions that have to approve a great number of transactions. That is burdensome for the turnover. And if you are interested in the conditions, in the consequences of non-observance of that approval, you will get the answer that this transaction can be contested against. And the interested reader will find the norm, a relevant norm in the law, and will read. If the transaction was not duly approved, it can be contested. And further, the next paragraph, the transaction will not recognized is if there is no harm related to the transaction. The reader would ask, but they haven't approved that transaction. And in fact, now we are witnessing a very super realistic situation. It has to be approved. If it is not approved and it is on normal terms, it cannot be contested against. And Elena Nikolaevna, as a legal consultant, probably is well aware of that, and a lot of money is spent to observe these rules of preliminary approval. And the companies that follow the law have to do it, and as a result, there are no consequences for non-approval, probably except for reputational and judicial expenses. But even from the judicial practice, you can see that the main reason for recognizing such transactions as invalid is the fact that they do not cause any damage. From the 1st of September of 2013, amendments were made to the chapter on transactions of the Civil Code, and there is Article Item 2, 174. Transactions are recognized as invalid if they are detrimental to the company. Then why do we need these institutions of major transactions and transactions with interest? The first purpose, let us strike out everything, and among those who are sitting here, there are some adherents of that standpoint. Even when they worked at the High Arbitration Tribunal, they were not fond of such institutions, but in my view, they have an independent function. We shouldn't judge about them as to their present description in the law. In fact, for 20 years we have been combating with these institutions, decreasing the possibility of contesting on these grounds without analyzing the foreign experience and why they needed it abroad. If we look back, for instance, using the large transactions, the example of large transaction, the transactions will see that they have an independent function, as was mentioned, that is no possibility of evading the rules on reorganization and liquidation. Globally, grounds are provided abroad of the fact that such transactions should be approved, and the competence of the general meeting should not be interfered with the managerial bodies. We know that the activity of the company, such questions are always resolved at the general meeting. They set up the company, they liquidate the company. Can it happen that a legal entity such as a company will exist, but it will not exist de facto if they sell out all the equipment and the building of the facility? Of course, the answer would be no if you ask whether anyone should be asked. There are some truncated examples in Germany. In fact, they are not available. That idea exists, for instance, in Spain. It is described under the Code of Corporate Management.
So in the corporate governance code, they are saying that, yes, those recommendations should be sorted out at the general meeting of the shareholders. Secondly, The substantiations for major deals are around, but they should be modified, mindful of that, to raise the hurdle on the value of the property to make this deal major one up to 50%. And also, it will be no big deal if in definition of those deals will refer to the fact that this is a deal which turns around or disrupts the company's activities. Maybe the participants of the civil circulation are not accustomed to that. I know that all the amendments are taken on board very, very cautiously. There are many reasons to that. We don't have to discuss all of them. There are some implications and undertones. Like we say, we wanted the best and you know the rest. Towards this end, frankly speaking, I don't see any grounds of the businesses and the participants of the civil circulation to be fearful of those changes, because at the end of the day, the amount of the approved deals will go down. They will right size on the costs, and the levels of guarantees for the participants is not going down because they can contest it. One way or the other, the deal which would be detrimental to them could be contested to them. Another one is to major deals, mindful of those things. We should change the conditions for contesting such deals. Currently, for that, we should prove the detriment because of that deal. But if it's, let's say, dissolution of the company, we don't have to see whether it's detrimental or not. It's not possible for the director to make the organization, when participants come along, he will say, I've made a fabulous organization, it will be lucrative for us. So one way or the other, of course, it's just the business proprietors to decide that. It looks like this. So this draft law just puts it in place with this basic concept. And I would like to underscore the fact that, of course, it was not about limiting directors' competence by different thresholds, but it should be part of statute of corporation. And bottom line, it should not be called major transaction. We have Article 174, paragraph 1. Why should legislator establish these thresholds of 25% like now for all the companies, even if it's not a public company, not listed one, but a small open joint company, close-end joint company with 5 shareholders? Trust me, mindful of the recent trends about discretionary principle in corporate law, they should be given leeway and discretion what they are going to approve and what they don't want to approve. And of course, they might establish that the general shareholder meetings would decide that, or the board of directors or any other person. Let them sort it out on their own. Of course, another thing is for public companies, in public joint stock companies, shareholders oftentimes are not able to introduce the decisions which would be enabling them to control that. Maybe for them this threshold could be done, but only for listed public companies, not for unlisted companies. That is about major transactions. As to related party deals, I sort of disagree with Nikolaev that those situations which are described in related party deals, they are utterly pointless and they do not track down the final conflict of interest. Oh, it's global practice. Overseas, these deals are referred to as related party deals. We identify a circle of different situations whereby we say we would approve that just to be on the safe side. The only thing which actually the only challenge for us for the legislation was that the first definition uses the definition of affiliated persons, and there were some approaches and some hot minds were saying that we should refer to affiliated persons not just as the list of those persons, but different examples, like even if your lover or boyfriend and so on, such deals should be proved as the related party deals, after which the business said it was outrageous. Yes, I said lovers. So thing is that this institution initially is all about setting up a list of situations. As soon as we start saying that we should take into account the actual relations, we disrupt the idea in the name, because it's only possible to establish that in court. There's no way of knowing it before. It's not possible to prove it before. There are some far-fetched situations, and they say if he has got some sort of conflict of interest, he should come along to the board of directors and seek the approval. But it's common knowledge that this is against those who are doing the abuse, and they will never come along to the board of directors speaking about that. Rather, he would deal with those unaffiliated persons without notifying anyone about it. That's obvious. And of course, it also contradicted one of the basic principles about the definiteness of law and substance of law. There could be some law casuses, and we should resolve them in a fair way, but substance and definiteness should be there. Draft law is enabling us to remove from related party deals the definition of affiliated persons, and to make this list way more straightforward for subsequent analysis and maybe prior to the transaction. These will be persons who are part of the board management, different directors, their relatives, next of kin, and majority shareholders holding more than 50% of the stock, and also their next of kin and their subsidiaries. You yourself or your next of kin, or companies like SPVs, if you create them, such transactions should be approved just like that. But second issue about those related party deals, why should we approve them in the first place? We have just heard that major transactions are de facto reorganizations or dissolutions, and they should be approval. Otherwise, the deal should be invalid. Is it the same with related party deals? The legislator wanted the director not to sign the deal with his mom. If he signed that deal with his mom, so right away it should be invalid. Not quite so. A legislator that way has been meaning to set up some ex ante procedure, something like a preliminary approval, some kind of an ex ante procedure to notify everyone about it, at least. Moreover, draft law goes further and introduces a proposal based on general rules of representation that the approval is needed for a counterparty. Subsequently, in court, wouldn't have to seek evidence to prove that he was right. They came along to the board of directors and say, we have a conflict of interest, please approve this deal. If on behalf of the company later on someone is going to contest this transaction, the company or shareholders will prove that this transaction is detrimental. Another issue is when the procedure wasn't complied with, there was no some preliminary or ex ante approval. In this case, the plaintiff will have to prove the damage. Let's say I am signing a deal with my next of kin. Of course, it's a conflict of interest, and then the shareholder is very angry about it. He comes along, and I'm showing that that was detrimental. Yes, the procedure was breached, but there will be no consequences for the violation of the procedure. There are none. So, together with the diminishing number of deals which are referred to as a related party deal, the same one, it's I may put it notional sanctions. Counterparty who entered the deal with conflict of interest without seeking approval from the counterparty, he will have to prove in court that that deal was made at arm's length deal in the same way as with any other third party without detriment. If you are evaluating procedure, if you are aware that it's not a good faith act, you'll have to bring evidence and to prove your point. That is about related party deal. Now, more generic remarks. We have a unique situation currently with major transactions and related party deal transactions. When you come to court to contest such a transaction, you have to beforehand prove, or it goes without saying that the counterparty is not a good faith counterparty. The deal is terminated unless it has been proven that the counterparty didn't know and couldn't know that such a transaction had to be approved. What does that mean? Unless the proof, if there, that transaction will be considered invalid. That means that a priori counterparty should do due diligence on all that. As a result, currently, all the Russian lawyers are rather straightforward about the idea. If you are signing a transaction, you have to scrutinize all those things, no doubt about it, period. This idea goes hand in hand that we should also validate the bylaws and statute of incorporation of the company. That's right, everybody scrutinizes that. And not just the articles of incorporation as well.
So the labor contracts and everything else. So we have a national sport in America. Everything should be collected. All the information about the deal should be collected. Abroad, the approach is quite different. If the internal procedures are not followed properly, if you have problems with the appointment of directors, then these are internal conflicts and they cannot be referred to the counter agents. With us, the risks are distributed differently. Everything is on the counter agents, and this situation is, as I see it, convenient for two categories. The shareholders, for the parties, because they have a wonderful situation. Their director, when the director is planning to sign a deal, everybody asks whether he wants to steal something from the shareholders. Well, maybe we should approve, just in case. And the other group of individuals, that's us. As a class, I mean lawyers, of course. Without this situation, then of course companies would not spend that much time and money on legal services, because really money is spent on this tax of documents. In any company, is, as I know, when there is this legal inspection, the favorite thing for the consultants is to write that if there is a deal that is not approved, approve it just in case, in order to avoid contesting. And all this is represented as legal analysis, although the general rule of the risk distribution is as follows. If you choose your representative, your director, then of course you are responsible for him, not the third party at all. And this is true also in connection with the presumption of the fault of the counter agents. So the presumption of good faith is emphasized in the civil code. The contesting of the unapproved deal in compliance with the statute is possible. A deal can be recognized void if it is proven that the counter agent was not in the know of something. So everything is on the plaintiff, actually. The burden of proof is on the plaintiff following these new provisions. Well, of course, everything is in the future with the practice acquired, because there might be exceptional situations when any third party, any observer would be quite sure that a deal requires approval, whether it's because it's a major deal or because it is a deal with a conflict of interest. So there was an attempt to mention that in the plenary of the Supreme Court, in the plenary decision of the Supreme Court. But of course, with the legislation we have, this is hardly possible, because the law focuses everything on the counter agents at present. Thank you very much for your attention. Thank you, Alexander. Now, we have a serious problem associated with that. I really have to ask our speakers to remember that we have an international legal forum, that not everyone who is here, the abbreviations they are using are clear enough concerning the laws and the articles. Let's remember that. And Alexander Anatolievich actually spoke about the content of the articles. Yesterday I heard this criticism about one of the roundtable discussions. One of the participants did not like the fact that the numbers of the laws were mentioned, the numbers of the articles were mentioned without clarification of what they were all about. That participant was from Kazakhstan and could not possibly enjoy what was being discussed. And so let's not forget that the problem we're discussing is regulated, apart from the corporate laws on different types of companies, also by the civil code and respective articles and the plenary decisions of the arbitrage court number 28 adopted. 28? No. A year ago, yeah, on the 16th of May. Yes, 28th or 16th of May last year. And I would like to address the attention of our foreign colleagues to the fact that the civil code of the Russian Federation is translated into English, published by the Research Center of Private Law, and there are several editions known already. But in Article 174 of this code, which is the key article in order to understand the issue, in the translation there is just one paragraph. It's the old version. Unfortunately, the new version has not been published in English yet. But we are carrying out this work, and in the near future the translation is going to be there. And the ones who suffered most of all from the reform is Alexander Zhiltsov, who translates the text of the Civil Code into English. And I heard from him lots and lots of negative comments concerning the texts. And he is interpreting now, translating now the text on the collateral. And of course, that's another voluminous piece of work. Now, colleagues, I suggest that we ask questions, and we would like to listen to your comments. Allow me to introduce a representative of the German Law School, Rainer Wedder. Fate brought us together at one of the events dedicated to corporate law held in Germany. And then Mr. Wedder amazed me with his knowledge of the Russian law, of the problems that we encounter in Russian law. And when it was decided that I would be the moderator of this particular session, I decided to invite Mr. Wedder. And I'm very happy that Mr. Wedder is with us today. And if he has comments, he is, of course, most welcome with them. Now, the priority to comment has Mr. Wedder. I would like to mention that that's an honor in a way, but it's also a responsibility. So I'm addressing now all the participants of our session. Any comments, any ideas you would like to present, questions? Thank you very much. Thank you very much for the invitation to the forum and for the introduction. Indeed, it's most interesting to listen to the presentations, and I was thinking of the comparative analysis of law and the positive aspects of that. You can learn that in other countries this doesn't work that well at all. I do know that for students, comparative analysis is not a favorite discipline at all, but we are practicing lawyers, so our attitude might be different. But as for the major deals or deals with a conflict of interest in Germany, deals with the conflict of interest is not a problem. Practically, there is no problem at all, because the law stipulates that Director General doesn't have a right to sign contracts with his relatives or related people in any way. So it's banned, as well as here. And 99% of the statutes absolutely exclude this, and so they this particular provision, and that means directors can have these contracts signed. But we don't have this problem, because in the public shareholding companies, in big shareholding companies, you won't find directors general who can act just by themselves. The principle is the principle of four eyes and maybe even and two keys. One director general in the big stock companies would have a right to sign a contract on behalf of the company. The second or the third director is needed for them. So there are no contracts that he can sign a contract with his mother, for example. It's just impossible. That's why we do not have a problem. But the absence of the problem is defined by a very different reason. The executive authority with us is differently structured, and this is something that we could probably discuss at a later stage. As for major deals, there are problems with that, because there is nothing at all in the legislation. There was a situation when one stock company sold 90% of the assets, and the shareholders disagreed. They went to court, and the Supreme Court in Germany said that in exceptional cases, the approval is required of the General Assembly of Shareholders. It's good that the Supreme Court ruled that, but he did not mention when the exceptional case comes. And the researchers said it could be from 10 to 20%, 90%, 24, 25%. In 24%, this meeting is not required. With us, it was not clear. Then there was a second decision of the Supreme Court, and they again did not give any exact numbers, because the judges did not like to speak about 30, 35.5%. They just spoke about exceptional cases, 90% or more. 25%, according to our opinion, it's not a major deal. And so 25%, this is clearly stipulated by the law, and still there are a lot of disputes concerning that. If there are, well, the judges very often deal with these matters of big deals. With us, the jurisdiction was not that clear, and we had certain problematic issues, but contesting in Germany of the deal by a shareholder is impossible. Shareholder can approve or disapprove if there is an exceptional case. If there is approval, then the shareholder can just contest the deal. And so if the meeting of shareholders is competent, and well, of course, I can speak at the meeting, I can present my arguments, and there is a hope that I get the majority of votes for non-approval. But then once the matter is settled and the approval is there, then the shareholder cannot contest. That's probably for the future for you. But we have another problem. If the shareholder does not have a right to contest the deal, then what would the shareholder do? Hire good lawyers and contest the approval. in Germany it is possible. In Germany it is possible to contest the decisions of the meetings of the shareholders. Sometimes a company is very much in need of a certain decision of the shareholders. For example, if it is necessary to increase the statutory capital. It is possible only if there is the positive decision of the meeting of the shareholders and if the decision is not contested. So shareholder can block the actions of the company. But if there are shareholders that act in bad faith and use this particular approach in order to make sure that the company pays for the approval. Taking away the right to contest the deals is probably a good idea, but let's not forget that there shouldn't be any grounds for the contesting of the approval, because again these are continuous disputes and they really did not allow the company to work properly. That's my opinion, the opinion of a foreign lawyer. I also have some comments concerning your presentation. As far as I know, you really do not have an institute similar to the deals with vested interest. But it is possible to contest a deal if it violates the rights of the paying out of profits. The profit of the company should be distributed equally between all. So it cannot be that we pay a certain amount of money to one shareholder and a different amount of money to another shareholder. So if there is a deal between the shareholder and the company, and the shareholder gets something at lower prices, then the question is raised, and what about the others? And this deal, as a result, can be contested, and all the money will be taken away, as I know. And my second comment, just in order to understand better, the countries of the continental law are not the best example in the field of combating the deals with vested interest, because there is concentrated capital, and those who it's the business that forms the capital, and no legislation infringing on the rights. As for the conflict of interest, these rules are much better developed and much more effectively used in the countries of common law. So if we take major deals, then of course Germany is a very good example in this sense. But as for deals with vested interest, I think even Germany recognizes that there is room for improvement. I know that in Germany there is a discussion of a directive that would, at the national level, decide which particular deals are to be approved.
Dear friends, we have to pass on from major transactions to other issues. There is a question from the audience. Please take the microphone. Filipenko Nadezhda Vladimir, teacher of the chair of civil law from St. Petersburg University. I have the question to Galina Nikolaevna, Alexander Anatolyevich. Since we are dealing on legal entities, not only related to the economic society, I'm interested in corporate relations. Sensu lato, it is interesting how the institutions of deals, the vested interest is developing, not only in respect of economic entities, but commercial, non-commercial, production, cooperatives, state unitary enterprises. I would like to ask, is there any legislative work in that sphere for harmonization of the institutions? I understand that the nature is the same of the deal with the conflict of interest. As to the production cooperatives, there were some amendments to chapter number 4, and the situation is not pleasant. As to distribution of the burden of proof in case of contesting of interest, in case of the transactions, in case of the conflict of interest. So the entities who contest these deals affected by the economic communities appear to be more privileged than those who contest the transactions with production cooperatives. I am interested in that issue. As to the work on the draft law, probably I can disclose the plans of the Minister of Justice in respect of preparation of the unified law on cooperatives that provided a systematic solution to the problem. Now the draft on major transactions and transactions with major interest take into account only several legal forms, and 19% or 95% of legal entities are non-state institutions, but that doesn't mean that we have forgotten about all other legal entities and we are going to change everything, being guided by the principles which I discussed with respect to the law on draft law on major interest and transactions and transactions with vested interest. Probably not always we need such detailed rules. In production cooperatives, probably they are commercial legal entities, and in non-commercial companies we might reduce the regulatory burden. The transaction with a conflict of interest. My apologies. Today, in the law on non-commercial organizations, there are norms on transactions with a conflict of interest, but they're too vague, and it is not clear what body should give the approval, what due to the change of organizational forms of non-commercial organization, it is not clear. The law on non-commercial organization doesn't apply to all types of legal entities of non-commercial organizations, and there is a gap in legislation. I have a similar answer. I have not just invented it, and we prepare a unified law, not only of cooperative, but amendments to the legislation of non-commercial legal entities. And for instance, it is planned that these vague norms probably will be removed from the law on non-commercial entities, because civil laws will be regulated by the civil code. As to the non-commercial organizations that will be assigned to the public registration, these are just preliminary ideas. Even if that norms remains, I mean, a deal with a conflict of interest, it will be clarified, and the problems which you mentioned will be solved. As to the time period, until the end of the year, probably some preliminary draft law will be drawn up. Please. Professor Dmitriev, head of the law service of GUP. We belong to those 5%. As to the major transactions, I'm interested. Do you know what criteria are used by the public authorities when they agree on major transactions? Because now, as to the approval procedure, that is resolution of the government number 739, and major transactions are agreed on with the state unitary enterprises. And now we have to agree on all the transactions above 5 million rubles and above 150 million rubles by the resolution of the chair of the government. So to get the resolution of the government, we need to spend a lot of time. time, and then competition has to be organized. As to the criteria used, we do not use the criteria related to the fact that the transaction can be contested in general, that the criteria of revenues related to the transaction, and they check the operation of the performance of the company as to the profit level, internal procedures. And here the situation is a bit different. General director has his own KPI on the performance, and that procedure on agreement on major transactions, in fact, kills the entire KPI, and he has to get the approval. Of course, they approve on the scope of activity. In business, we have quick and dead companies, and VGUPs are at present in this situation. VGUP Goznak, for instance, we have about 60 transactions per annum over 150 millions, and per month about 80 transactions above 5 millions. And we, the Rosimущество and Ministry of Finance, have to agree on these transactions. And please take it into account, because we are not the last of GUP, and soon will become a joint stock company, and the rest of the GUPs remained in our former life, in our previous life. Thank you very much. And the last question concerning this problem. Someone has got a question now? Thank you. Then thank you very much. And now let us pass on to the next problem. And now I would like to give the floor to Maxim Nikolaevich Bunyakin, managing partner of Brennan Legal. He's a person who is actively involved in the work on amendments, including the prepared amendments to the corporate laws. And I think that since we don't have enough time and we have many speakers, I would like to ask Maxim Nikolaevich to concentrate on some key issues that are of great concern to business and legal consultants in application of the norms of the civil code and probably the laws on joint stock companies and limited liability companies. Thank you, Vladimir Vladimirovich. Good morning. I'm happy to welcome you to such interesting afternoon. Andrei Vladimirovich just paved the way initially, and I think that the spirit of our discussion is quite free. So yesterday afternoon, I doubted what presentation should be displayed, and now I would like to ask you to switch on my presentation. Today, after Andrei Vladimirovich has made his statement, I have no doubts as to what presentation should be showed, so this should be removed. You can control it using the buttons. So I decided to show this version, and I will briefly highlight on the main problems that were revealed in the course of the first analysis of the civil code. Please do not be strict. We have to be optimistic, because optimism helps us to work with that civil code, to amend that civil code, and you will see that without optimism it would be rather difficult for us. How have we met the emergence of the new civil code, the first response? So the situation was like that. So that was our first feeling when the new civil code appeared. I'm speaking about legal entities. Entities were not discussing other provisions, so we'll live following the new civil code, and we hoped very much, and we have prepared for that. So on the 1st of September it was enacted, and 9 months have come during which the ideas were formed. As to how it operates, probably something has to be changed again, and that is an approximate list listing the problems which obviously remained. First, I thought that the screen would be large, but it is small. There is a definite responsibility of the main company with respect to the transaction of the subsidiaries. And the second problem is the multiplicity of several personal units. We have discussed it with my colleague from Germany. We were not only using the same Russian language, we use the same legal language. And will you please comment on it later? Probably will prompt us how to solve some problems. Then implementation on norms and on composite organization. We were waiting for this, but not everything can be done now at present, and business, particularly holding companies and medium-sized businesses and large businesses needed, then notarial certification of decisions, resolutions taken by correspondence. So there is a significant gap, the gap that cannot be removed either by explanation of the notarial service or amendments to the law notariate. So the decisions have been suspended. Everywhere we hear, complaints of the large business, prohibition to set up the subsidiaries, and the colleagues have to introduce an additional shareholder, though de facto, and the responsibility is not available as well. And finally, the last statement is implementation of the right to exclude a shareholder. Previously, you could only exclude the participant, but how should he be excluded? The schemes are quite unpleasant. For instance, I submitted.
The society is paying for it. There are no arguments, so we removed part of money out of the company. This mechanism is not yet prescribed, and profile laws are lagging behind. Let's get down to 3 major problems. I'll expand on them. Of course, it's possible that we'll have to amend civil code at least. I think that life goes on, everything changes, and 9 months after the enactment of the civil code, small changes could be introduced as well. So the liability of the parent company versus subsidiary, let's say there's the consent of the parent company. We discussed that what should be referred to as consent. Only deal approval, a corporate deal approval of major deal or other deal, is it consent or not? Defining the position of the subsidiary company, a letter from a parent company, whatever, in the written form or in the oral form, verbally, whatever, that there will be consequences for a parent company as solidarity liability on all the economic activity, not just in bankruptcy. The last draft law didn't cover that, so it was sent back to the ministry. In the recent edition, I didn't find it. So the proposal was the following. First of all, it was proposed, but it's not part of this draft law, at least. This consent is considered to be identified if it's envisaged in the agreement with the subsidiary or in these articles of incorporation of the subsidiary, or also to entitle the subsidiary to exclude parent company liability, and counterparty may sign this deal, or otherwise he says this condition should be changed. That's when the parent company will be liable. But unfortunately, it's not part of draft law yet. Getting down to several executive bodies. Civil code is saying that there could be one acting independently or several such bodies or agencies. We have got about 8 options how we do it. You can share your powers or do it separately. 6 or 8 interesting options, interesting for joint projects, interesting for let's say corporation or let's say there are different functions within a company, but why is this norm yet falling flat? I know some of the colleagues try to implement that in venture projects, but they're fearful of doing that because what should be done if different decisions were made in once and the same day? The articles of incorporation are a bit muddled up about it, and the counterparty will get the wrong end of the deal. And unfortunately, we don't have Svetlana Vichenko here, but I might say that there should be records about it, that there are several of those, and they work separately or in the, together, and we should not mimic this article of incorporation and by law until the laws are changed. Yet counterparties are taking a risk when they make such deals, and there was the idea to refer to the mechanism of substitution one of the three persons. Let's say you have got 3 persons, something happens to one of them, so his or her powers are redistributed between the remaining 2. You don't have to convene the general meeting for that. And the highly judgmental point, how to distribute those powers and liabilities. Some say it's great, we'll appoint one person responsible for all and liable, the other one will be doing that. But when central bank or other regulator would knock on our door, we'll point a finger at the other one. So this is a big problem, of course, it's well known. And it's civil liability, tax liability, administrative liability, and maybe even legal liability, although the qualification and the elements of the crime would be clearly seen and traced if you are acting together. Whatever, colleagues, we need amending it urgently, or we should say that this mechanism is invalid and maybe it should be removed from civil code. The idea was to suggest 3 of those, following Russian tradition, like the Trinity, 3 of them, or maybe 5, but it's not yet regulated. Another important issue, I would like to tell you about it from the perspective of convenience for business, because civil code and other laws in many ways should be helpful to businesses and ensue from businesses' needs, not the other way around, it seems to me. So what evolved? It's there used to be a dividing balance sheet, and also the lenders' rights were changed. There are some more extra guarantees envisaged for them. Sometimes lenders are not participating in this process, are not notified. There is a 3-month lockout or moratorium for, and also it's possible to reverse it. As to the reorganization or restructuring, you may say that the reorganization is not happening or is invalid because there is no detailed procedures how to go about it, and it's rather difficult to turn around this reorganization because it means that some participants quit from this organization, so it's also not working yet. And good news are that, first of all, it's possible to let participating in the organization to companies of different organizational forms. That's just great. We're very thankful for those changes, and I tried to reflect that in the first slide. I'm grateful for that because imagine a holding company with several companies, and previously they had to have a common denominator for all, so to put it, and to work based on it. But it could be utterly pointless if everything belongs to me or to shareholders, or secondly, if it's a very big company there are buybacks, inventory, and so on. So not everything is functioning smoothly, but some organizations have been done in some of the companies. The last but not the least is a combination of different forms of reorganization, acquisitions and mergers, and sharing. Before it was only for non-governmental pension funds. I'll explain why it's there. Now, most important is to be aware that now it's possible to combine different forms and different legal entities. Simultaneously, you can combine both parts of this puzzle. I am positive, and it seems to me altogether that we should not interpret the civil code like a entirely new form of organization which is there. We're speaking about the combination of those forms of restructuring and organization. It's just possible to combine them differently. Why is it needed or might be needed? Not to go into details, I might say that this is a cost-efficient way of transferring assets, transferring business for major companies and holding companies. That way, you identify some of the types of activities. You've got several companies with core businesses, non-core businesses. You take core business, identify it separately, separate it, and then you join it to some other chunk. So this is very important if you are going to dispose of the company lately. If you are going to go up with the asset, you had the granddaughter company, you moved it up, and you turned this company into the subsidiary. It's much faster than two parts like identification and separation. Let's say someone wants to separate business. Let's say I want to do the production. You will be involved in the logistics. You may separate business via restructuring. And it's possible to use the different coefficients. It's also restructuring. And inside the holding from within, you may transfer one asset into another place without losing control over it. It's possible through restructuring or organization. Conclusion, colleagues, we should do it in a cost-effective way and use this instrument. Of course, the first euphoria has dissolved because when we started studying this instrument in depth, we understood that something works smoothly, some yet falls flat. But it's crystal clear that for that to work, to start working smoothly, we'll have to slightly amend civil code in certain parts. There are minor corrections which should be done, but there should be profile laws, and we're thankful to our colleagues from Ministry of Justice and Ministry of Economic Development and to all the companies who come up with very good proposals. It should be done promptly because we're 9 months after, and now yet the ministries are approving that. So in order to be quite optimistic for way out into the future about all those issues, I would like to wish you great success. Let's work on it. Let's roll up our sleeves and work on it. And it will be very lucrative for all of us. Thank you. Thank you very much. Maxim Nikolaevich, colleagues, have you got questions on that presentation? Maybe comments, remarks? But if you ask questions, you should ask questions in a very careful way, and they should be you should be very knowledgeable. Okay, be brief because we have a presentation by Alexandra Makovskaya. We have got even 2 presentations, so we should be brief. I have a small comment to that presentation. I'm Elena Lvova. I'm a legal director of Bank Открытие. Bottom line for business is stability. All the changes into civil code, without any doubt, are impacting business. Civil code is a living and breathing document. That's the way it is. That's the way it should be. But all the changes introduced should be well conceived, carefully thought about. Not just like you change here and there, but 9 months after, if it falls flat, we'll change something else. come on, guys, that way the business will stall and be stuck. Now, when businesses turn to me with the question whether it's possible to sign the deal or not, which risks do we have here? It's like a nightmarish fairy tale with no options. Either way you go, you'll get the wrong end of the deal. What are we supposed to do? Life will be tough that way. So when some changes, any changes whatsoever, are introduced into legislation, think about businesses, think whether they will be able to work in such conditions. Of course, you can say we are going to turn it around, everything will be different, we'll follow British law or German law, whatever. But some articles which are unchanged are incompatible with those which were changed. So altogether, it's a very grim picture. Thank you very much, Lena, for this remark. And I think you are calling upon businesses as well to be involved, to be engaged in that, because unfortunately there are lots of platforms for discussions and hearings out there, but nobody comes along. But when the law is enacted, they say, how come, why is that? And when I'm asking those companies, did you introduce any changes? Sometimes they were just very passive. There are different venues for discussions: Ministry for Economic Development, Ministry for Justice, interdepartmental venues, the venue of legal forum here. Companies should come up with their proposals. Thank you. Very interesting roundtable. Maria Abramova, Gazprom Neft Group. We are discussing the changes in legislation. Currently, we can use that like mixed reorganizations and restructuring, which should be quite helpful to us because businesses are developing. We keep changing business structure, the asset structure. Those novelties should be helpful to us. I don't have the representative of the Ministry for Charges and Taxes and Levies here, but this forum of mixed organization is there. We would like to use it, but when in the Urals, in Novosibirsk or in Sverdlovsk, in Yekaterinburg, come along to the tax authority and say, we need mixed organization, help us. They say, we don't have a circular, we don't have explanations, and most likelihood will say no to you. You won't be able to use this norm in practice. I have a question about legislation. Everything is great. We are going to change the law on joint stock company, on public company, and so on. But when will it be applied in different regions and places? Microphone, please. As to Minister of Justice, yes, but tax authority is registering the legal entity, so we should turn to it. Microphone is not used. Andrei Vladimirovich, I'll answer this one. Yes, unfortunately, Svetlana Fedchenko for the Ministry of Taxes and Levies is not here, but all that problem was discussed. This problem has been around for 10 years, since the law on joint stock company appeared. Tax authorities were saying, no way. We had to explain those authorities what's to be done and to change the forms. What is the current situation? There are problems in the regions because they've never ever done that, but as to the norms of mixed restructuring, those forms are around, apart from maybe separate tough cases. It depends. The forms which are there in the tax authority, they cover legal entities, but not just joint stock companies. You may do it similar to the law, because there is a law on joint stock companies and there is a civil code. So my tip to you, quite practical, if that happens to you and you know that will happen a priori, turn to Ministry of for Justice and also to the authority and the Authority for Taxes and Levies. Dear colleagues, take a chance, but you should put together and foster this practice. And
now, here is what I think. Probably do not quite understand the topicality of the issue, but the tax authority, no, the law says that legal entities and individuals can act like that, but the tax authority says you can do whatever you wish, but we do not have the forms approved. So what is the mechanism of the public control over this type of behavior on the part of the tax authority? Well, of course, we can go to the forum, we can test and try all sorts, but after 9 months, nothing is being born, nothing is being changed. I think the civilized society invented the judicial system exactly for that, where we can challenge the lack of action on behalf of the public authority. And we had some serious discussions pertaining to that, and the court ruled something that the tax authority listened to the opinion and changed the situation. So I think the active civil society in this sense can act and should act, not only explaining its position but also going to court. No, this is not that good from the point of view of the system, but if nothing else works, then this is probably a possibility. Now, Helena, well, there's one more question and then we go to the next topic. I would like to generalize one of the issues that Maxim spoke about, because my experience of a practicing lawyer is definitely associated with the responsibility of the parent company and the subsidiaries. So we need to remember Article 105 in this context, and it has to be resolved in the context of the overall problem of the responsibility of the shareholders and the controlling entities to the debts of the company. It's Article 53 that prescribes this responsibility, and the controlling authority now has to act in good faith and with due diligence. And it's quite interesting indeed. This is what requires attention. In this article, we can find some information about the responsibility of the directors. They must act in good faith, and we might extrapolate that to the controlling entities. But the approach should be different, I do believe, and the directors should be not just acting in good faith and reasonably, but also remember we're talking about good faith in a different context, whether he is acting in the public interest or not. So the director doesn't have this alternative. Director needs to act in public interest, and so there is a great risk that we might extrapolate this type of good faith over the controlling entities. We must understand what criteria are to be used for the definition of the responsibility of the shareholders on the debts of the company. And the final question. Now, any problem of corporate law, I think, could be discussed at length indeed, particularly if there are real professionals who discuss the matter. But we should not forget that apart from the problems of stock companies, interests of business, there are other problems associated with the non-commercial organizations, and we would like to listen to a presentation dedicated to that. I'm Armand Girdalin. I represent a law company from Kazakhstan. No, executive authority represented by a single person and by several entities. In Kazakhstan, a college of directors for limited liability companies is an option that has been existing for 10 years, but in reality it's quite an exotic option. And I know just a couple of examples of that. In our company, we have an example when a client decided, although we did not recommend that to him, to create a body of 9 individuals who are all number 1. But with a different client, I really would not have understood how they worked, because they could easily lead to the stopping of business. But under these circumstances, when the company was transnational and it had its own internal regulatory systems in respect of jurisdictions, so there was primus inter pares, and he makes the decision on coordination, and that provided for the proper implementation of this institute. But if we take general grounds, if we take ordinary business, then how would they act if there are 4 eyes, 2 keys, and 3 keys? The reform that has been started here and does not limit the maximal number of individuals to act on behalf of the legal entity, particularly if they have to act in consensus, then it's a serious problem. I know that in the Western countries this problem is being resolved. I saw some rules, I can't remember, in Belgium probably, that a number of directors can be from 3 to 7, or from 2 to 5, so there is a limit. A reasonable limit. Experience of Germany is very interesting in that, so we can ask Rainer to share his experience. Allow me to come up with 2 more comments from Germany. With us, this system, the system of several individuals in one entity, who can act on behalf of the society, of a company. It's not exotic at all. It's part of the law, and it's a right. And it's bad, I think, that until last year only 1 director could be director here. There are legal aspects associated with that, and there are mentality issues as well. With us, it is a tradition. Big joint stock companies might have 10 directors, 10 individuals who work there together, who can arrive at a compromise and who can all act on behalf of the company and sign contracts and agreements. Usually out of these 10, there are 2, A and B, let's say, or A and D. So these 2 will work together, but not 1 primus inter pares, so who decides everything by himself. So there are compromises, and it's a joint management, and it works. So not only in the stock companies, but in the limited liability companies as well. Well, of course, one person cannot do everything. As always, there must be agreement of the second or the third. Legally, how does that work? It is stipulated that some individuals can speak on behalf of the company, and it's either A, B, or A, B, and C and D. So it's all clearly stipulated. And I don't think Russia has an answer to the volume of presentation, whether they can sign all types of deals or just to $100,000. And the charter can say that each of these directors would have different responsibilities for certain types of agreements and contracts, but it's going to be very difficult for the register. Register would have a very long list and nobody would know what it tells about. Here is what we suggest. A person always has a certain right to speak on behalf of the company, and it is not needed to go to the register in order to find this out, because the law contains all this information. So deals with the third parties and always a certain competence. But within the company, it could differ. So sometimes this executive entity, executive body, in relation to others, has a right to sign a contract, but by the internal rules does not have it. And it's also the matter of personal responsibility. That's another interesting matter. The responsibility of the authorities, of the bodies, has been reformed, but there is a big difference. With you, a company or a shareholder needs to prove that there was a damage, and this particular entity violated the regulations or the rules. With us, it is different. A company needs to prove that there is damage, and then this executive body has to prove that it acted in good faith. If it cannot prove good faith, then it has to pay. This is a rather effective way for the executive entity, even if this entity has a right to sign agreements in violation of internal rights, would not do it. And another general comment, if I may. So these rules concerning responsibility of the parent company, or the rule concerning responsibility of the executive entities, no. It's typical of Europe, as you said. Thanks to the European Union, we have quite a serious competition of legal norms within the EU. But it's all leading to simplification. It's possible to establish an entity, legal entity, without any capital, which is a risk for minority shareholders and for the counter agents. What might happen as a result? We understand there is nothing good in that, and then there is the idea of the responsibility, and we make the rules of the involvement of the parents' company more stricter. The same goes for the rights of the director. So as a result, we have a company that can be created just overnight, and the responsibility of the acting individuals is lower than earlier. Is that good at all? Maybe it is better to create higher barriers for the establishment of a company. Maybe there should be different barriers for the capital, for the documentation. Because if there are very simple rules, then we need to think about the stricter rules regulating the responsibility matters. It's a philosophical matter, what comes first, and we're discussing that because the European Union creates these conditions, and in Germany there might appear cooperatives from Slovakia. So is that a progress or not? I'm not sure. I would like to thank you, Mr. Wedder, first of all for speaking Russian, although it is not easy for you, but you make it so much easier for all of us. There's no need to listen to the interpretation. Because simultaneous interpretation sometimes leaves out certain details. Now, dear colleagues, we also need to discuss non-commercial organizations because the many parties express their concern. The owners of housing speak up with their questions. There are lawyers' firms that also encounter certain questions. So what are the rules to make work more comfortable and easier? I want to give the floor to Viktor Chubarov, Vice President of the Chamber of Commerce.
Thank you very much. It is with great hazard that I came to that audience because I understand that here we have many corporate lawyers from the commercial companies. But as to the questions, as to the problems related to non-commercial organizations, they're also quite acute, and I would like to say a few words about the reform which started from the 1st of September 2014 in respect of non-commercial entities. What decisions were taken taken while preparing for the reform, it was ascertained that we have more than 20 types of non-commercial organizations, and some types are artificially distinguished. And it was ascertained that the whole number of non-commercial organizations by their generic features can be combined, and that the political parties, social organizations are also a non-commercial organization, a legal civil form that makes it possible to engage in the activity for which such non-commercial organization is set up. It was decided to prepare a concept that non-commercial organizations should be classified under corporate and non-corporate. In the last case, there are some funds and institutions, and as to the rest, they are non-commercial corporate organizations. And another decision was taken in the course of the concept. It was not passed as a reform. The norms contained in the laws on certain types of non-commercial organizations should be mainly assigned to the civil code, and the civil code will describe the procedure of organization and arrangement and existence of a non-commercial organization. The essence of the reform is such that according to Article 50, we have 11 types of non-commercial organizations. For instance, the partnership of the owners of property, of housing, consumer cooperatives were mentioned. I would mention the Association of Unions that comprise the Chamber of Commerce and Industry, Advocates Chambers, Notarial Chambers, unions of employees, and other non-commercial organizations. Safeguard, well, the rule was just stated that the types of entrepreneurial activity or activity giving revenues is possible under non-commercial organization if it is provided by the statute or by the law, because initially it was planned that all types of activity giving revenues have, in accordance with the draft, have to be provided for in the law and in the statutes. As to how the reform proceeds, it proceeds with great difficulty. The Chamber of Commerce and Industry became the members of the Association of Unions, and revealed certain discrepancy between civil code and the federal law on non-commercial organizations. If in accordance with the law on non-commercial organizations, if in any case, the general meeting is the higher management body of the non-commercial organization. According to the civil code, when we speak about associations and unions, if it is up to 100, that is general meeting. If it is more than 100, that will be a conference or a congress. We have a rather complicated system, and I would like to say a few words about the system of chambers of Commerce and Industry. We have 178 chambers in Russia. It is headed by the Chamber of the Russian Federation. They law on the chambers of Commerce and Industry in Russia, and the statutes say that that system should not contradict the statute of the Chamber of Commerce and Industry of the Russian Federation. We have congresses once in 5 years, and we make amendments to the statute of the Chambers of Commerce and Industry, and it is subject to expert examination at the ministry. We submitted the statement to the government that the amendments to the law should be made, and the minister asked the vice Prime Minister Mr. Shovarov. He gave an order to the Minister of Economic Development and Minister of Justice. They agreed, but they said if the federal law of non-commercial organization is changed, we should apply an integrated approach. And they say that 10 months have passed after the reform started. As to how to approach that law on non-commercial organizations, that is an open question. The law is not simple. I would compare it with, for instance, Chapter 4 deals with legal entities in the civil code. the variety of Chapter 4 in respect of non-commercial organization is in federal law non-commercial organization, and what should be done with it, and how we should reform the law on non-commercial organization. That is not simple. It is an open question. The representative of the Ministry of Justice said that we were doing it, but we are not doing it as actively as the situation requires. Life makes us make reform, and we prepared a concept on harmonization of law on non-commercial organization. It was prepared by the joint working group of the Minister of Justice and the Council of President on Development of the Civil Society and Human Rights, and that concept was submitted to the Council on Codification and Improvement of the Civil Legislation by the Committee of Krisheninikov, because they're actively reforming non-commercial organizations, and later I will tell you about it. And I'm the member of that council, and we concluded decided not to support that concept because it was not mature. There was a norm that apply with the application to business and legal entities. As to the reforms, we have to use a careful and weighted approach, because there was a concept just to develop probably a separate civil code for non-commercial organizations, to add specifics to regulation of the rights to trademarks, to participatory shares. Of course, that is a wrong approach, because that should be the civil code of the Russian Federation. And it was said that the law on non-commercial organizations should apply to all types of non-commercial organizations, including non-commercial organizations which included specific non-commercial organizations such as political parties and professional unions, which are not assigned to the common group of non-commercial organizations. And it was said that we need a special regulation for public organizations. These are non-commercial organizations that exist on the basis of the law, but nothing was said as to what should be done in respect of reforming. So what should we do? I'm not asking who is to blame, because in Russia that is a rhetoric question. We have vast areas in Russia and a lot of snow, but what should be done? That is a serious question, and those who have the laws on specific type of non-commercial organization might feel free. They can add civil legal norms applicable for that type of non-commercial organization with respect to the norms contained in the civil code. We conducted this work. We have prepared the amendments to the law on chambers of commerce and industry of the Russian Federation. It was it is being approved, it is being passed to the State Duma. As to what should other non-commercial organizations do, there are some initiatives related to the draft law prepared by the committee of Pavel Krashenikov, who had to attend our section, but he is now attending the section on inheritance. We're optimistic, and I support you, because today I wanted to probably to attend the round table on inheritance. Probably Oran is going to die, and he will tell us how to inherit business. And he added some draft laws together with Khovansky, 3 draft laws on regulation of the matters related to the partnership of the owners of housing. As to the tax service, that is not a partnership of the owners of real estate, and according to the housing code, it applies only to the partnership of owners of housing, not owners of real estate. That is one set of problems. Pavel Vladimirovich made some brave steps by 2 draft laws, one of them together with Mr. Plegin. He offers to expand the list of non-commercial organizations contained in Article 50 due to advocates' chambers and advocate units that are legal entities, and later these will be notarial chambers. And we have the system of Chamber of Commerce and Industry, and we have a question whether it is a step back to the future or a step back into the past, because these organizations were independent types of non-commercial organizations, nevertheless proceeding from some common features. They were assigned to the associations and unions, or just membership, voluntary membership, but the advocates said that the membership is mandatory and the notaries also repeat, and they want to be segregated. So if we analyze how this draft law develops and how the initiatives develop, probably we'll ask a question about departing, about leaving them, and will come to the situation when the chambers of commerce and industry were an individual legal organizational forms, as was written by Vladimir Veryansky in the first wording of the Civil Code. So what are our proposals concerning the law on non-commercial organizations? For instance, the transactions with vested interest, they are really vague. We have major transactions, but we proceed not from the law, but from the analogy of the law, and we approve such transactions so that there will be no question to us as to the transactions with vested interest. That is a separate question. I would like to support you, and we shouldn't interfere with the maximum turnover among the non-commercial organizations. The transactions are not as frequent, and stringent requirements to the business described by my colleague today are quite evident. We have been approving these transactions for 20 years, and they will stop the turnover for non-commercial organizations. We think that we have to remove from a law on non-commercial organizations section 1 and 2 concerning the structure of the management bodies and the subject. As to the public part, registration, control, supervision, reporting of non-commercial organization, that should be left in the federal law on non-commercial organization, and that should be done as quickly as possible because that is a large family. And I understand the corporate investors who represent non-commercial organizations who are working with them. We have 50,000 members when we offer our venue, and you can come to us. And last year we followed 100 draft laws. There is a large family of non-commercial organizations which live and exist, and not all of them can reach chambers of commerce and industry. Though answering the question what should be done with registratory bodies, sometimes we give recommendations that you should wait while they refuse you, and then we'll see. Thank you. Dear colleagues, it is with great sadness that I realize that I haven't managed to be an adequate moderator, and I remember the film on the novel by Agatha Christie, 10 Little Niggers. There was also a moderator, but we shouldn't give such a cardinal answer to that problem. So I have to make the final remark probably. So I wanted to highlight on many problems that we have discussed today, but nevertheless, counting on your understanding, I will give the floor for the brief presentation to Alexandra Markovskaya. It is clear that you have the right to coffee break. It is close to the rights and freedoms of the person, and anyone can present in 10 minutes, and Alexander will be able probably to make a presentation in 2 minutes. Not many people are capable of doing it. Alexander Istanna, I'm quite sure. Alexander Anatolyevich gave best regards to Oleg Romanovich Zaitsev, multiple in his presentation. I will try to be very brief, summing up the results of our session and of our discussions of the problems related to corporate law, I think that all corporate investors today are classified under two groups that were represented here in your wonderful poster. I belong to that group. You should be on alert if you're a lawyer, and from the viewpoint of the checking who and to what extent can represent the sole executive authority of the corporation. I'm afraid that we can refer to the statute to analyze it, or to the charter, and other colleagues were quite outspoken. They say that we don't have to look into the charters, and bona fide will not be related to the charters. I think that I belong to the lawyers who are pessimistic, and I live following the principle that it is better to be on the alert. And my apologies, I would like to give the best regards to Alexander Markovsky, with whom I was engaged in maritime law, and he said that one of the good principles in maritime law is that the shipmaster has to be closer to the hazard. And I would like to highlight on a very brief problem. We know that this was one of the main ideas involved in corporate regulation, that is this positivity of optionality of regulation of corporate legal relations. Let us say that in corporate relations we should transfer the principle of freedom of agreement. You can agree on anything you want, you can write anything you want, and currently the civil code of optional regulation of corporate relations with respect to non-public society is perceiving openly. I'd like to tell you that it's one thing to have freedom of agreements in the relations that covers only those who are partners to the applications, and the agreement concerns only the parties to the agreement. And another principle of freedom of regulation of corporate relations applicable to legal entities. Can you tell me why the parents have no right, for instance,
why the parents are not given the right to give the birth date of birth to their children following the French Revolution calendar, like 8th of Brunei, or write down that the children are dwarfs, elves. So when it comes to legal entities, there should be obvious and clear-cut understanding of who we are dealing with. Those changes in the civil code identified four very important problems. First challenge, and let's admit it. Currently, we're not going to have those public companies, the set of discretionary powers embedded into civil code, and the extra discretionary powers will mean that all of us will be entirely different unless we follow the uniform bylaws in the company. There will be huge set and options how competences could be identified. It could be more than 8 different types. Tell me, please, as to the competence of the agencies, because via those bodies, the legal entities identify the rights and obligations of persons in the civil circulation. Apart from several issues in civil code, the competence of the shareholder meetings could be referred to collegiate managing body, and the competence of the collegiate body, or there could be the competence of the executive collegial body. Do you think that the board of directors will be executing different things? That means that today we should be explicitly aware if in non-public society there will be such a patchwork. We should look into the articles of incorporation Apart from that, there is another challenge. This is the discretion. You are given this discretion to establish anything whatsoever. Another problem is we are going to write this down in our own words. Each one of them, it will not be a law because a law is uniform about the wordings. One lawyer will write it that way, another lawyer will write it this way. Third challenge is here. Discretionary powers are at a rather bizarre level. This discretion, the law provides us with this discretionary power. You can write in the bylaw of the company one thing, in articles of incorporation and internal documents you can write something else, but there is one more important provision. Those internal documents of the company should not contradict articles of incorporation and bylaw, and also there is a corporate agreement. In the corporate agreement you may write down anything whatsoever. In this situation, corporate agreement could contradict the internal documents of the company and articles of incorporation. The more higher level of discretionary regulation, the more sophisticated system is, the more chances are to make a mistake. You were asking, two CEOs are concluding a deal. I'm not very much concerned with that. Okay, two representatives acting on the power of attorney, they made two deals on behalf of one entity. The obligations are there, but when this document is to be regulated differently, but it's one and the same legal entity, we should be very, very careful. We should be very careful about using this discretionary power. Tatiana, there is another procedural problem around. If, let's say, a legal entity is regulated by a law, in this case, I always have a uniform norm in relation to which the uniform application and enforcement of this norm will exist. If I need the provisions of the articles of incorporation and of the bylaw to assess it, the court could decide differently, but let's say it's a dispute with other legal entities. In such a situation, there will be no interpretation of the articles of incorporation. So one and the same legal entity will be following different rules. So it seems to me altogether that this discretionary power should be used based on one principle. Let's keep in mind that freedom is a well-perceived necessity. We should be explicitly aware of what we're doing and why we're doing that. Then we might use those discretionary powers. In the law about LLPs, some issues should be resolved much prompter and better than what's offered now. Thank you. Thank you very much. Denis Vasilyevich, you'll be able to discuss things with Alexander during coffee break. I kept looking at my watch. I thought that there would be lots of other questions, but then one more man came in and joined up with us. So this room is full, and now I can see a colleague of mine who is here listening to what we are saying. I would like to say hi to her as well. But let us do the stock taking. Let's summarize. It seems to me that we had great time together in all those discussions. And I appreciate the organizers' offer of this hall to us, because the voices were not reverberating. We didn't hear voices from other adjacent rooms. Thank you very much. See you soon.